Maxwell versus Dow. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Did you know that? A U.S. citizen doesn't have the access to the first 8 amendments against the powers of the federal government. The only absolute and unqualified right of a U.S. citizen is to residence within the territorial boundaries of the United States. A U.S. citizen is literally a slave. It's a piece of property. Such construction ignores the rights of a state in virtue of its sovereignty to confer citizenship within its own limits, where the rights incident to such a status are not of the citizenship mentioned in the federal Constitution. It does not follow that because one has all the rights and privileges of a citizen of a state, he must be a citizen of the United States. Since a distinction has long been recognized, such a distinction has long been recognized in this county. And that's a reference that's referring Dred Scott versus Sanford, which is a U.S. Supreme Court case, and that is actually taken from a Mississippi court case. The rights of the original judicial citizens of the states as such are not under consideration in the 14th Amendment. They stand as they did before the 14th Amendment and are fully guaranteed by other provisions. And that's U.S. Supreme Court again. Actually, no, that's U.S. versus Anthony before it went to the Supreme Court. Civil rights under the 14th Amendment are for federal citizens and not state citizens. Federal citizens as parents have no right to the custody of their infant children except subject to the paramount right of the state. So, citizenship in Canada is the same thing. It exists in Canada. The Charter adopted in 1982 refers to citizens of Canada several times. The courts have told us that laws of Canada are federal laws. Citizens of Canada are federal citizens. Canadians include state, which is the provincial citizens, and federal citizens. And this is the Charter. It says every citizen of Canada, Section 3. And in Section 6.1, it talks about every citizen of Canada. And 6.2, and 23.1, and 23.2, and 23.3. And in Section 3, it says every citizen of Canada has the right to vote in the election of members of the House of Commons. So what that's saying is elections are commercial elections. And Section 28 says, notwithstanding anything in this charter, the rights and freedoms referred to it are guaranteed equally to male and female persons. Okay, so a citizen of Canada is a person, is a fictitious entity. And this is a California court case. It is evidence that they, U.S. citizens or citizens of Canada, have not political rights which are vested in citizens of the states. They are not constituents of any community which is vested in any sovereign power of the government. Their position partakes more of a character of subjects than of citizens. They are subject to the law of the United States or Canada as applicable, but have no voice in its management. If they are allowed to make laws, the validity of these laws is derived from the sanction of a government in which they are not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. And so we'll go into this a little bit more. A subject or national may indicate being a member of the sovereign state, especially one owing allegiance or democratic forms and usages. Owing an allegiance, sharing individual political rights. Subject may imply a state of subjection to a person such as a monarch. A national is a more general word, may apply to anyone owing permanent allegiance to a nation and indicates one belonging to a broad category that includes both people who are citizens or subjects, but also people who have not attained such legal status. Okay, so again, a citizen or a subject is basically a citizen a subject can be a citizen, but not necessarily. And a national is someone that's not a citizen or a subject. And so that's Merriam's third new international dictionary in 1986. A subject, Black's Law Dictionary, one that owes allegiance to a sovereign is governed by laws. The natives of Great Britain are subjects to the British government. Men in free government are subjects as well as citizens. As citizens enjoy rights and franchises, as subjects they are bound to obey the laws. The term is little used in countries enjoying a republican form of government. That tells me that the U.S. is no longer a republic. Proud versus Gore. This, in our opinion, it was not the intent of the legislature to restrict the operation of the statute to those who were only who were subjects of the United States government, and to exclude therefrom unnaturalized residents of foreign birth, whether black or white. And that's 1922. And so again, they're talking about subjects of the United States government. U.S. versus Anthony. The 13th, 14th, and 15th Amendments were designed mainly for the protection of the newly emancipated Negroes. Okay, so again, the 13th, 14th, and 15th Amendment are for U.S. citizens. Downs versus Bidwell, U.S. Supreme Court. On the other hand, the 14th Amendment, upon the subject of citizenship, declares only that all persons born and naturalized in the United States and subject to the jurisdiction of thereof are citizens of the United States and of the state wherein they reside. Here there is the limitation to persons born or naturalized in the United States, which is not extended to persons born in any place subject to their jurisdiction. And so there's a difference. They're differentiating there. The persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. And that's Elk versus Wilkins, U.S. Supreme Court case again. The term citizen in the United States is analogous to the term subject in the common law. Okay, so this is all common law, really, if you think about it. And so back before the Civil War, they were called subjects, and then after the Civil War, after the 14th Amendment, they became citizens. Citizenship is a term of municipal law. Citizenship carries with it the idea of connection or identification with the state and a participation in its functions, and as such implies much more than residence. And so therefore, U.S. citizens can murder their unborn children. The unborn are not included within the definition of person as used in the 14th Amendment. And this is Colgate versus Harvey, U.S. Supreme Court. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. In other words, they criminally converted citizenship into the opposite of what they intended, what the Founding Fathers intended. Citizenship is a political status and may be defined and privilege limited by Congress. Yes, U.S. citizens can. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. Okay? In other words, prior to the 14th Amendment, U.S. citizen did not exist. Bowling versus Commonwealth. The 14th Amendment referred to slavery, common law, consequently the only persons embraced by its provisions and for which Congress was authorized to legislate in the manner were those then in slavery. And then Van Valkenburg versus Brown. No white person born within the limits of the United States and subject to their jurisdiction or born without those limits and subsequently naturalized under their laws owes a status of citizenship to the recent amendments of the federal Constitution. And they're talking about 14th, 15th Amendments, 13th. And this is in the United States Code right now. Go look it up. Title 42, United States Code, Section 1982. It says all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. And so that's right there, right now. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. A U.S. citizen, that's U.S. Supreme Court, a U.S. citizen upon leaving the District of Columbia becomes involved in interstate commerce and as a resident does not have the common law right to travel of a citizen of one of the several states. And after the adoption of the 14th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the major purpose of which was to secure to the recently freed Negroes all the civil rights secured to the white men. None other than citizens of the United States were within the provisions of the Act, and that's U.S. Supreme Court again. A subject, one who owes allegiance to a sovereign and is governed by by that sovereign's laws. Speaking generally, we may say that the terms subject and citizens are synonymous. Subject and citizens are alike those whose relation to the state is personal and not merely territorial, permanent and not merely temporary. This equivalent, however, is not absolute, for in the first place the term subject is commonly limited to monarchical forms of government, while the term citizen is more especially applicable to in the case of republics. And that's Black's Law Dictionary, 8th edition. Finally, it is to be noticed that the term subject is capable of a different and wider application, which includes all members of the body politic, whether they're citizens or resident aliens. All such persons are subjects, all being subject to the power of the state and to its jurisdiction, as owing to it at least temporarily fidelity and obedience. Black's Law Dictionary, 8th edition. Residence, this is taken from Vattel, okay, and this explains it very well. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to society by reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it, they must defend it, although they do not enjoy all the rights of citizens. They only have certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. So, again, the Law of Nations is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 13, page 87. And so, again, that's what a resident is, okay? And so that's what a U.S. citizen is. One does not necessarily become a non-resident, absconding or absenting himself from his place of abode. And so it's all in what you tell them. Residence, the fact of being officially president, the statutory president of incumbent in a benefice. That's Funk and Wagnall's dictionary. It might be correctly said that there was no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. Every taxpayer is assessed a K trust. Having sufficient interest in preventing the abusement of the trust must be recognized in the field of the court's prerogative jurisdiction. So a U.S. citizen's a fictitious entity is what it is, okay? And so this has absolutely nothing to do with race, really. Taxpayers are not state citizens. This is in Southern Reports. Slater's protestation to the effect that he derives no benefit from the United States government have no bearing on his legal obligation to pay income taxes. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. And that's the U.S. District Court in Delaware. When you're traveling, and then there's the U.S. border pigs. When you're traveling across the border, you tell the U.S. border pigs that you're a state citizen, and they say, we don't recognize state citizenship. How can you spell treason? The U.S. border pigs are deliberately and calculatedly engaged in treason by making that statement. The U.S. border pigs are under the direction and supervision of Holder, the bar member whore, and his hired thugs in the Office of Attorney General Corporation. And the Canada border pigs are too stupid to know anything about the two classes of citizens. The Canada border pigs are under direction of bar members like the bar member pig McKay and the bar member pig Nicholson and the pig Harper and the pig Tays and the pig bar member Johnston, who was the governor general. He's another bar member pig. And the ultimate responsible is with Elizabeth the bitch. No disrespect to dogs intended. You know, a dog doesn't sit there and make you think he's your friend and stick a knife in your back like Elizabeth the bitch does. We're going to talk about some court cases that talk about race. And we've kind of talked about them a little bit here, but the court cases talk about race are used to talk about what was once considered subjects. Because of the so-called 14th Amendment, all subjects became U.S. citizens. And I want to stress again that race has nothing to do with this. This has everything to do with its corporate law, and I don't care what race you are, you can be a sovereign. Matter of fact, we'll talk about that more. Anyways, in that Chisholm versus Georgia case, it says, but they are sovereigns without subjects, unless the African slaves among us may be so called. And it's the U.S. Supreme Court. This is an 1854 court case. No black or mulatto person or Indian shall be allowed to give evidence in favor of or against a white man. The words Indian, Negro, black, white are generic terms designating race. Therefore, Chinese and other people not white are included in the prohibition from being witnesses against whites. Excluding Chinese witnesses in suits to which white persons are parties is affirmed. And in the indicium of color is not an infallible test to the competency of a witness under the Act excluding blacks, mulattoes, and Indians from testifying for or against white persons. In a criminal action against a white person, a black or mulatto person, though the injured party, cannot under a statute be a witness against the defendant. The words in favor of or against any white person in the Act prohibiting persons of one half or more Indian blood or Mongolian or Chinese from giving evidence refer to the defendant alone in a criminal action. Okay, so what these cases are basically saying is that it's talking about these other races before the 14th Amendment. They were citizen subjects. and after the 14th Amendment, they became U.S. citizens. The 14th Amendment to the Constitution of the United States does not conflict with the power of the legislature in the exercise of its discretion to exclude Chinamen from the right to testify in state courts. The evidence of a Chinaman cannot be admitted to provide a white man guilty of manslaughter. The right of trial by jury in civil cases guaranteed by the 7th Amendment. Okay, so now this is talking about subjects, okay? And this is talking about, it's all admiralty, it's all Roman civil law, and again, the way you get subject to this is they get you in a contract. Anyways, the right, and it's all coming from the Vatican. I got to tell you, it's these bar members that are doing it. Anyways, the right of trial by jury in civil cases guaranteed by the 7th Amendment and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileges and immunities as citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution except by indictment of a grand jury contained in the 5th Amendment and in respect to the right to be confronted with witnesses contained in the 6th Amendment. Okay, so again, that's the U.S. Supreme Court said U.S. citizens don't have access to the first 8 amendments to the Constitution against the powers of the federal government. And so they're basically saying the same thing in this case. The technical niceties of the common law are not regarded. A jury does not figure ordinarily in a trial of an admiralty suit. The verdict of a jury merely advisory and may be disregarded by the court. The rules of practice may be altered whenever found to be inconvenient or likely to embarrass the business of the court. In other words, we want to railroad this guy, and so we'll just bend the rules here a little bit. A court of admiralty acts upon equitable principles. A libel of information accusation does not require all the technical position of an indictment at common law. If the allegations describe the offense, that is all that is necessary. Is founded upon a statute is sufficient if it pursues the words of the law. And this is talking about admiralty and these equitable courts, these kangaroo courts, these UN courts that you see operating these days. U.S. Constitution, Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Okay, so a subject is property. Okay, so a U.S. citizen is property. Okay, you're a slave. That's exactly what a U.S. citizen is a slave. But they have to gather evidence against you, and again, it's not about race. It's all about slavery, and it's all about corporate law. There have always been 2 classes of citizens. The citizens of each state shall be entitled to all privileges and immunities as citizens in the several states. Okay, so that's the U.S. Constitution, Article 4, Section 2, Clause 1. And then it goes back to Leviticus, even talks about 2 classes of citizens. But the stranger that dwelleth among you shall be unto you as one born among you, and thou shalt love him as thyself, for you were strangers in the land of Egypt. That's exactly how they enslaved the children of Israel, is they used that 2 classes of citizens. Love ye therefore the stranger, for you were strangers in the land of Egypt. Deuteronomy 10 and 9. And the U.S. Supreme Court even uses these terminologies. The rights of sovereignty extend to all persons and things not privileged that are within the territory. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they're within his territory and owe a temporary allegiance in return for that protection. And that's, again, U.S. Supreme Court, and they're using this strangers terminology that's taken right out of the Bible. Strangers have a social security number, a social insurance number, Deuteronomy 23:19-20. Thou shalt not lend upon usury to thy brother, or usury of money, usury of victuals, usury of anything that is lent upon usury. Unto a stranger thou mayest lend upon usury. So they want a social security number so they can verify that you're one of the slaves. You're a stranger. Think about it. The bankers, thieves will not loan their so-called money unless you can prove you're a resident.